If you have any kind of immigration case in the United States right now, a visa renewal, a green card process, an asylum claim, a work permit, a family petition, or you are living without status and keeping your head down, you need to pay attention to what happened in Washington this week because the House just pushed forward three major immigration bills in February 2026 that could change the rules faster than most people realize. And the next few months are where people either get ahead of it or get blindsided by it. I cover immigration updates for regular people, not lawyers, not lobbyists, not political junkies. So I am going to translate what matters into plain English, keep it practical, and give you an action plan you can start today. Because whether these bills become law exactly as written or get rewritten in the Senate, the direction of travel is already clear. Here is the big picture before we get into details. One bill is built around tougher border and interior enforcement. Another bill tries to speed up and modernize legal immigration and reduce backlogs. And the third bill creates a long conditional route for certain undocumented people to earn legal status over time. That combination is exactly why people are feeling two emotions at once, hope and fear. Because depending on who you are, one part might help you while another part could put you at risk. And if you live in Texas or you have family in Texas, this matters even more because Texas sits at the center of the border conversation, and it also has one of the largest immigrant communities in the country. So policy shifts tend to hit there first and feel louder on the ground. Now, let us walk through what each bill is trying to do, who it could affect, and what you should be doing while the Senate fight plays out. Because the mistake I see over and over is people waiting until something becomes law and then they rush. And in immigration, rushing usually means mistakes, missed deadlines, and bad paperwork that follows you for years. Bill 1 is the enforcement-heavy package. You will hear it described as a border security and interior enforcement bill. And the core idea is simple: more money, more technology, more agents, more detention capacity, and tougher consequences tied to unlawful entry and certain violations inside the country. The way supporters sell it is that the system is overwhelmed and they want control and predictability. The way critics describe it is that it expands enforcement in a way that can sweep up people who are not threats, and it makes humanitarian processing harder. In practice, the bill sets up a large multi-year funding stream for physical barriers and reinforcement in high traffic areas, plus surveillance systems like cameras, sensors, drones, and monitoring towers. And then a major hiring push for border personnel and interior enforcement officers. The numbers you hear around bills like this can be huge, tens of billions across a few years. And the detail that matters for you is not the exact dollar figure, but what it buys. It buys manpower and infrastructure, which usually means more encounters, more stops, more workplace visits, more detention beds, and more capacity to move cases quickly. One of the biggest operational shifts in this enforcement bill is how it treats asylum at the southern border. Right now, many people who show up and claim fear of returning to their home country can be released into the United States while their cases move forward, depending on the situation and the capacity of the system. This bill tries to end or sharply limit that release for many asylum seekers by keeping more people in controlled processing, including the idea of processing centers outside the United States in partner locations, where initial screening interviews happen before someone is allowed to enter. The stated purpose is to reduce what lawmakers call weak or fraudulent claims and to stop the incentive for people to cross expecting release. The concern from advocates is obvious. If you push vulnerable people into facilities outside the United States, you create safety issues. Access to counsel becomes harder, and mistakes in early screening can have life and death consequences. Another piece of this enforcement bill is the push for speed inside immigration court. On paper, faster decisions sound good because nobody wants a case to drag for 5 years. But speed cuts both ways. When the government sets strict timelines, like completing detained cases in a matter of months and non-detained cases within about a year, you can end up with people who do not have enough time to find a qualified attorney, gather records from another country, get affidavit translated, collect medical proof, or track down police certificates. So, yes, faster can mean clarity, but it can also mean more denials simply because people could not build their case in time. The third part of the enforcement bill, and this is where a lot of lawful immigrants need to listen closely, is how it expands the list of issues that can trigger removal proceedings. Most people understand that serious crimes can lead to deportation consequences. The problem is that proposals like this often broaden the definition of what counts as a removal trigger by adding a new category tied to public safety. That category can include things that many people do not emotionally file under deportation, like certain driving-related offenses, repeat traffic violations, some misdemeanor domestic violence findings, and select drug possession charges. Depending on the final language, even a longtime green card holder can end up facing immigration consequences for conduct they thought was behind them. Let me make that real with a story scenario, because this is where people get lulled into a false sense of security. Imagine a man named Carlos in Houston who has had a green card for more than a decade. He works, he pays taxes, his kids are citizens, and his life is built in Texas. Years ago, he made a stupid decision after a wedding and got a DUI. He handled it in criminal court, did the classes, paid the fines, stayed out of trouble, and he moved on. In his mind, that was a closed chapter. Under a tougher enforcement framework that adds more deportability triggers, that old case can become the spark that puts him in removal proceedings if immigration authorities decide it fits the new category. Now he is not arguing his case in criminal court anymore. He is in immigration court fighting to stay in the only place his children call home. His defense might depend on a very high hardship standard. And those standards are not the kind where you say, my kids will be sad. They often require showing something unusually severe, like special medical needs, extreme dependency, or unique circumstances. And even then, the outcome is never guaranteed. The point of this story is not to scare you into panic. The point is to make you stop assuming that a green card makes you untouchable or that an old misdemeanor is invisible. If enforcement expands and definitions widen, the safe move is to treat every legal issue as potentially immigration relevant and get proper advice before you plead to anything, even if a local attorney tells you it is no big deal. That is Bill 1 in a nutshell. More enforcement capacity, stricter handling at the border, faster court timelines, and broader consequences for certain violations. Now, Bill 2 swings the pendulum in the other direction, at least on the surface, because it focuses on legal immigration reform and backlog reduction. This is the bill that many skilled workers and family applicants have been praying for because the current system can trap people in decades-long waits, especially in certain employment categories and for people born in certain countries. One of the most important changes in this legal immigration reform bill is how it handles country-based limits for employment-based green cards. Today, there are caps that limit how many employment green cards can go to nationals from any one country each year. And that creates massive backlogs for countries with high demand. The reform approach being discussed in the House is to remove or relax those country caps, so visas are issued more strictly by priority date, meaning who has been waiting longest rather than by country of birth. If that kind of change becomes law, it can dramatically change the timeline for many people from high-demand countries who have been stuck in the queue for years, sometimes for a large chunk of their adult life. The bill also raises the overall number of employment-based green cards available each year and builds in a mechanism to expand availability when demand is clearly above supply. That matters for industries that are constantly hiring, like healthcare, engineering, and technology. And it matters for immigrants because more visas and more rational allocation usually means less waiting and fewer years living in limbo. For Texas, with major job markets in places like Austin, Dallas, Houston, and San Antonio, it could mean companies have an easier time retaining talent, and workers have a clearer path to stability. But Bill 2 is not only about work visas, it also reshapes parts of family immigration. The House version increases the number of family preference visas available and creates a faster processing lane for some immediate relatives like parents of adult citizens trying to cut the years of waiting that can separate families even when the relationship is straightforward. Here is the catch, and this is where people need to pay attention to details. Bills that shift numbers around often do it by taking from one category to feed another. In this proposal, one family category is likely to be reduced or eliminated for new filings, especially the category that allows citizens to sponsor siblings. If you are from a community that relies heavily on sibling petitions, that is not a small tweak. That is life-changing. Sometimes proposals include grandfathering, meaning if you filed before the law takes effect, your petition can continue. But if you did not file in time, you might lose that route entirely. The bill also touches programs like the diversity visa program. Depending on the political compromise, it may keep it but reduce the number of slots and reallocate those visas to clear other backlogs. That kind of rebalancing is a political move, and it creates winners and losers depending on where you were planning to apply from. Another major part of Bill 2 is modernization. If you have ever dealt with USCIS paperwork, you already know the pain points. Paper forms, unclear tracking, long waits, and inconsistent communication. The reform bill pushes for a more complete shift to digital filing, better online tracking, and more standardized remote or digital processes where appropriate. It also expands premium processing, which is basically a paid fast lane for certain applications. That can feel unfair because it creates a two-speed system, but it also can bring in revenue that agencies use to hire staff and improve processing for everyone. The responsible way to talk about this is that it may improve speed for some categories, and it may create a sharper divide between people who can pay and people who cannot. The reality is that even if you never use premium processing, upgrades to systems can reduce delays overall, but only if the implementation is competent and the funding actually goes where it is supposed to go. Now, before you get excited and start making big life decisions, here is the grounding point I need you to hear. A bill passing the House is not the finish line. The Senate can rewrite it, split it, merge it with other bills, or block it completely. So if you are in an employment backlog and this reform sounds like a miracle, do not quit your job, sell your house, or make irreversible moves based on a proposal. Treat it as a potential tailwind, not a guarantee. Keep your status clean, keep your filings consistent, and be ready to move quickly if the law changes. That brings us to Bill 3, the most emotionally charged one, because it deals with undocumented immigrants and creates an earned pathway to legal status. The language around this is always heated, so let me strip it down to mechanics. This is not immediate citizenship. It is not a magic reset. It is a long conditional process that says if you meet strict requirements and you stay clean and you keep proving yourself over a period of years, you may eventually reach a green card and then later citizenship. The proposal sets a cutoff date for continuous presence in the United States. In the House version, it is tied to early 2020, meaning you must have been living in the United States since that date and stayed continuously with limited exceptions to be eligible. If you arrived after the cutoff, you are likely out. It also sets criminal bars, generally excluding anyone with felony convictions and limiting eligibility if you have more than a certain number of misdemeanors. It requires background checks and biometric screening. It requires proof that you are working, in school, or serving as a primary caregiver in a household. It includes an English requirement and a basic civics knowledge requirement, not to turn people into historians, but to ensure applicants can function and participate at a basic level. If you meet all of that, you apply for a temporary lawful status that lasts for years, often close to a decade. And during that time, you have obligations. You keep working or studying. You pay taxes. You avoid criminal trouble. You report regularly, and you renew on schedule. After that conditional period, if you stayed compliant, you can apply to adjust to lawful permanent residence, meaning a green card. And then after the standard waiting period for green card holders, you can apply for citizenship. When you add it up, the timeline from undocumented status to citizenship is long, often more than a decade. For some people, that feels discouraging. For others, it is the first realistic legal path they have ever seen. The difficult part is the proof. A bill like this demands documentation, showing you have been physically present since the cutoff date. That means paperwork with your name and dates across multiple years, leases, bills, school records, medical visits, bank statements, employment records, tax filings, letters from community organizations, and sworn statements from people who can credibly verify your presence. Here's the problem. Many undocumented people survive by staying informal. They pay rent and cash. They share housing without a lease. They work jobs paid in cash or through arrangements that do not produce clean pay-ups. They move often. They avoid paperwork because paperwork can feel like risk. So when a pathway requires a paper trail, a lot of eligible people struggle to prove what they lived. The proposal also includes significant fees. Depending on the final version, it can be thousands per adult, plus additional fees later to adjust status, plus eventual naturalization costs. And that is before you add attorney support, translations, and the time cost of building a strong file. On top of that, conditional status programs often restrict access to federal benefits for a period of time, meaning you may be allowed to work and pay taxes, but still be blocked from many supports outside emergency care. That can be a major burden during job loss, illness, or family emergencies. So yes, the bill offers a door, but it is a door with a long hallway behind it, and you have to be prepared for that reality. Let me bring in a realistic example story here, because this is the kind of situation I get messages about every day. Picture a woman named Marisol in San Antonio. She came to the United States several years ago with her children, and she has been working cleaning houses and helping families with caregiving. Her kids go to public school. She has been here long enough to meet a 2020 style cutoff, and she has stayed out of trouble. On paper, she could be the type of person this program is built for, but her life has been informal. She moved apartments twice. In one place, the electricity bill was in someone else's name. In another place, she rented a room and paid cash. For work, some families paid her weekly without formal payroll. She has some messages on her phone, some money transfer receipts, some school letters, and maybe a clinic visit record, but it is scattered. If the application window opens, she is not just filling out forms. She is rebuilding years of her life into a timeline the government will accept. That can take months. It can take help. And if she waits until the last minute, she may miss the chance or submit a weak file that gets denied. This is why I keep saying preparation matters even before anything becomes law. Now, we need to talk about what happens next, because this is where people either calm down too much or panic too much. These bills pass the House, but the Senate is a different battlefield. The Senate can demand major changes to get enough votes. Sometimes bills get merged into one larger package. Sometimes the most controversial parts get trimmed. Sometimes the bills stall and nothing becomes law. Also, even if the Senate passes something, the final text has to be reconciled between House and Senate, and then it goes to the president. And even after a signature, implementation is not instant. Agencies have to write regulations. USCIS has to build forms and online systems. Officers have to be trained. Courts have to adjust scheduling. Facilities have to be funded and constructed. So, if you are wondering, does this mean raids tomorrow or a new legalization form next month? Typically, no. The machinery of government moves slower than headlines, but slow implementation does not mean you should wait. It means you should use the time wisely while other people are distracted. So, what should you do right now, depending on who you are? If you are undocumented and you think you might qualify under a continuous presence cutoff like early 2020, start building your proof file today. Treat your life like a timeline you are going to have to prove year by year. Go back and collect what you already have. School records for your children, vaccination records, clinic receipts, apartment correspondence, bank statements, pay records if you have them, and any official letters with dates and your name. If you do not have formal documents for a period, think about who can write credible letters based on first-hand knowledge, like a landlord, a pastor, a teacher, a coach, a neighbor, or an employer, who will put their name and contact information on a statement. Keep everything organized in date order, preferably with copies stored securely, because losing originals is common, and it can become a disaster later. If you have been filing taxes with an ITIN, stay consistent and file on time because tax returns can be powerful evidence of presence and responsibility. If you have not been filing, do not guess your way through it. Talk to a reputable tax professional who understands immigrant situations because the goal is to do it correctly and avoid creating new problems while trying to solve one. Also, avoid any criminal trouble, even minor. Do not assume a misdemeanor is harmless. Do not assume a plea deal is safe. If you have any past case, even dismissed, get the certified court disposition papers because immigration decisions often turn on exact records, not your memory of what happened. If you are on a temporary visa, be obsessive about compliance. Keep your address updated. Do not work outside your authorization. Do not overstay and keep proof of your status. When enforcement rises, small technical violations can become bigger obstacles. If you are waiting for an employment-based green card and reforms could reduce your backlog, do not gamble your future on politics. Keep your current plan intact, stay in status, renew what needs renewing, and be ready to act if the rules change. In many cases, the people who benefit fastest are the people whose paperwork is already clean and current when the change arrives. If you are a United States citizen who plan to file for a sibling and you see any serious risk that the category could close for new cases, filing sooner rather than later can matter because lawmakers often protect petitions filed before a law takes effect, but they do not protect wishes. If you are an employer sponsoring workers, start scenario planning. Identify which employees are stuck in long queues and what changes could mean for them, and coordinate with qualified counsel so you can move quickly if new visa routes open. Finally, and this is non-negotiable, watch for scams. Every time big immigration news breaks, scammers show up like clockwork. They will claim they can file applications before the government even releases forms. They will pressure you to pay cash fast. They will promise guaranteed approvals. Real immigration work does not look like that. Use licensed attorneys or accredited representatives. Demand written receipts. Never sign blank pages. Never hand over original documents without making copies and understanding exactly why they need them. I want to pause here and do a quick recap because this is a lot and I want you to feel grounded. The House moved 3 big pieces at once: stricter enforcement and border operations, legal immigration modernization and backlog relief, and a long conditional legalization route for certain undocumented people. The Senate and the President are still ahead, and the final text could change, but the themes are already shaping what 2026 is going to feel like for immigrants in the United States, especially in places like Texas. And this is the part that is easy to miss. Even if you love one of these bills or hate one of these bills, the practical move is the same. Get your documentation tight, keep your record clean, stay in status if you have it, and do not let delay make decisions for you. Let me give you one more story scenario near the end, because it ties all of this together. Imagine a couple in Dallas. One spouse is on a work visa and has an employment-based green card process in motion. The other spouse has a complicated history, not criminal, but an old overstay from years ago that they have been afraid to revisit. They hear that backlogs might improve and they immediately start celebrating, thinking the green card will arrive quickly. But then enforcement language tightens and the couple realizes that any mistake, a missed renewal, a wrong address update, a bad legal assumption could trigger scrutiny at exactly the wrong time. If they take action early, they can sit down with a qualified professional, map out risks, gather records, correct gaps, and make a plan that does not depend on one bill passing perfectly. If they do nothing and just hope, the same policy shift that could have helped them might end up exposing their weak point. That is why the people who win in periods like this are not the people who guess correctly about politics. They are the people who prepare for multiple outcomes. So here is what I want you to do after you finish this video. Do not spiral. Do not assume this is all good news or all bad news. Pick the category you fall into and do the next right step. Build your proof timeline if you might qualify for an earned status program. Tighten your compliance if you are on a visa. Handle any past legal issue like it could have immigration consequences. Keep your filings current if you are in a backlog, and file family petitions sooner rather than later if a category you need could be at risk. This is how you protect your options while the government argues. I will keep tracking what happens in the Senate, what gets amended, what survives, and what the realistic timelines look like once agencies start implementing. If you want those updates without missing them, like this video so it reaches more people who need it, subscribe so you stay informed as the story moves, and leave a comment telling me which situation you are in. Employment backlog, family petition, visa status, asylum, or undocumented, and watching the earned pathway, because I read the comments to decide what guidance to cover next. And if you want a smart next step right now, watch my next video on how to organize your immigration documents into a clean timeline file that is easy to update every month. Because when the rules change, the people with organized proof move first and stress less.